I'm a big believer in second chances, even for people who commit serious crimes. Who deserves a second chance? Who gets one? And who decides? I'm Jessica Henry, and I'll be your host of Just Justice. I'm a former public defender, a professor of justice studies, and an award-winning author. And I'm excited for us to find new ways to put justice back into our criminal legal system. Hello and welcome to Just Justice. My name is Jessica Henry, and I'll be your host. Today on Just Justice, we're talking with someone who spent nearly 30 years fighting for people at their most vulnerable. My guest is Iris Eytan, founder of Protect Ethical Prosecutors, PEP, a nonprofit dedicated to ending what she describes as a nationwide epidemic of prosecutors who break the rules and face no consequences. She's a former deputy public defender, a founding partner of Eytan Nielsen, and a civil rights advocate. And I am so excited to talk with you about your work. Welcome to Just Justice, Iris.
Thank you for having me.
So let's just do some background here first. When you first started as an attorney, you were working at the Disability Rights Advocate and Disability Law Colorado. And that means you were working with some of the most marginalized people. And I'm wondering how you got from there to public defense to where you are now, challenging the power of some of the most powerful actors in our criminal legal system, the prosecutors.
It's a long story, but I'm going to keep it short. Disability rights work, I went into it to help people. That's it. I wanted to help people using the power of the law, and people that were marginalized, people that were hidden, and that needed someone to stand up for them. And what it ended up teaching me is that the legal system often reaches for the most blunt instrument first. And, it taught me that there's always more than one way to understand a person, more than one way to solve a crisis, more than one way to create safety. And representing these invisible people was interesting because they were invisible to the institutions until the institutions wanted to control them. And that shaped me profoundly. And it taught me to look for the person behind the file, the disability behind the behavior, and the trauma behind the charge, and the humanity behind the accusation. And many of the people that I was representing in disability rights advocates were people that were in the criminal legal system, and they were being charged with crimes, and there's questions whether they were insane at the time or whether they were incompetent to proceed. And that experience taught me something that I carried into criminal defense. And that's why I went into criminal defense, because I couldn't help them from the position that I was in as a disability advocate, because they were all being funneled into jails and prisons. But the prominent reason they were there was because of their mental illness or the developmental disability. And so what that experience taught me was that locking up people was not the same as making people safe. And what it taught me was we need to treat people, about how to treat people like human beings, and with dignity, with services, with accountability and compassion. And it's not softness, but it's often those things that create safety. And so that's why I was drawn to the criminal defense aspect, because that's where the Constitution really becomes real, or it becomes a slogan. And that's where public defending really came to be really a part of my heart.
Yeah, and I loved what you said about how the system's just nowhere to be seen for people who are struggling, whether it's with poverty or addiction or mental illness, until it's time to prosecute and convict them. That's such a powerful insight. And I get what you're saying about how we just don't do it well.
No, we don't.
We don't do any of this well.
We don't do it well.
So there's one case that shaped, from what I understand, the trajectory of the rest of your career. You were a public defender, and you were assigned the case of Barry Morphew. And I'm wondering if you could tell us about that case, because you realized early on it wasn't just a regular prosecution, that something down and dirty was going on. Tell us what happened.
Well, let me just correct just a couple things. I wasn't a public defender when I represented Barry Morphew. So while I was a public defender earlier in my career, what the important thing about that tie-in to representing Barry Morphew is that, and the work that I had as a disability lawyer, was that even more so in the criminal legal system and as a public defender, you understand that these concepts, these constitutional rights, like the presumption of innocence and due process and proof beyond a reasonable doubt, that they mean something when the government wants a conviction. But again, they're kind of slogans that people use, oftentimes prosecutors, when they want to sound like they want to get like the public trust. And I learned in being a criminal defense lawyer that, these rights don't enforce themselves, that someone has to stand there next to the accused and insist on these rights. And so after I was a, public defender, I went into private practice with the promise that from the firm that brought me in, that I could continue doing my pro bono work, helping people that had mental illness, that were being institutionalized because of their mental illness. And then I started my own law firm, and that's when I was hired by Barry Morphew to represent him. Okay. So I want to be careful about Mr. Morphew because he's been charged again. He's actually been indicted, and he is presumed innocent. And I want to say that loudly because it does mean something. My comments now are about the first prosecution and the accountability issues it exposed. I am not representing him through this indictment of his second charging or indictment. Okay, so what made me feel fundamentally wrong about Barry Morphew's prosecution? He was prosecuted for murder of his wife. At the time, his wife was missing, and there was no body, there were no remains to tie him or anybody else to her murder or her missing or her kidnapping. And what ended up in the years long work that I did for him in the case was not just one missed deadline of the prosecutors or one hard fought ruling. It was a pattern. The defense that I was leading, we were not receiving information we were entitled to. Yes, deadlines were missed, expert disclosures were mishandled, and material evidence that the prosecution presented as their theory was not fully and fairly presented to the judge and the court when decisions of his liberty were being made, like whether or not he should stay in jail while the case was pending, whether or not he should be on bond without release, option of release before the case was tried. So he was arrested and held without bond for murder of his wife, while important forensic and DNA evidence excluded him from the murder and or missing of his wife, and was not fully and fairly presented to the judge. And it wasn't a technicality. That's a difference between fair process, due process, like I was talking before, like the slogan of that, like we believe in due process, and a distorted one. So when the judge in that case started to issue rulings, holding the prosecution accountable for breaking the rules, for what I call misconduct, the response from the prosecutors was unexpected by the public. It wasn't to correct their course, right? Okay, we messed up. We didn't do this right. It wasn't fair. And the response instead was to try to get the judge off the case. You know what? And so the prosecutors investigated unsubstantiated criminal allegations against the judge after he made rulings that they didn't like. And to me, that was the ultimate abuse of power. And using government power, not against the accused, but against the judge, enforcing the Constitution. And discovery, like this discovery that prosecutors have to produce to the defense, that's how we prevent wrongful convictions. That's how we prevent even having a second chance, right? Because the first chance should be fair. And judicial oversight is how we protect the process. But when prosecutors withhold evidence and then turn their power toward the judge who's enforcing the rules, the system stops being a search for the truth and becomes a misuse of power.
Hmm. Wow. And so that's pretty extraordinary. That's a pretty extraordinary length. I mean, I write about wrongful convictions. That's one of the areas I do research in. And, to hear prosecutors playing fast and loose with the law isn't really a surprise, unfortunately. But I haven't really heard too many cases where they've gone after the judge to get them off the case when the rulings aren't going their way. Um, but in your case, you were sort of saying to the judge, hey, they're not doing the right thing. The prosecution tries to get the judge off the case. I'm assuming it did not work. And then there was a sanction against them, right? I mean, the judge said, fine, if you're not going to do what you need to do, we're not going to allow you to call certain witnesses because you haven't complied with the rules. And that seems like a pretty big deal.
That's right.
Yeah.
And especially because, in this particular case, they had canine dogs come to the house where they believe she went missing from, and the cars that were in the garage and the outskirts of the home. And these canine dogs are specialists in identifying decomposition, right, or blood. And nothing was found. DNA, forensic evidence, like nothing tied itself to Barry. And so and in fact, what it tied to were other maybe alternate suspects, if anything. So it's expert forensic evidence. People kind of understand it more now, but it's phone data, DNA, timelines, pathology, investigative, conclusions. So for the judge to bar 11 of 16 of these prosecution experts, it's extraordinary. It means the
Yeah.
court, right, found the prosecution's violations enough that the defense we couldn't prepare to meet that evidence, right? And the prosecution essentially wanted us to hunt through millions of pages of material, millions, and figure out for ourselves. Go find what they analyzed and actually go figure out what their opinion's going to be when you get to the trial. Expert disclosure is not supposed to be a scavenger hunt. You cannot ambush somebody with science when their liberty's at stake, right? You can't do that. And so, but that's what happened. They made it a guessing game, and the government was burying evidence and called that disclosure. Oh, we gave it to them. We gave it to the defense, Your Honor, and the judges said no. That's not the rules. That you're violating the rules and you're hiding evidence from the defense.
Yeah, and we have this adversarial system, and the idea is that it's supposed to, through this adversarial system and cross-examination, the truth will eventually emerge in the courtroom. And when they try to conduct a trial by ambush, that doesn't really work. In fact, it subverts the principles of justice of finding the truth. Now, after the case happened, what is so extraordinary to me is that after the case was over, you called a press conference and you named names. You sort of said, these are the prosecutors who did not obey the judge's rulings. These are the prosecutors that tried to go around the Constitution. And you filed a formal complaint against them, which almost never happens ever. It's really bold and really extraordinary. What made you go public?
So, on April 19th, 2022, when I was in court, the prosecutor at that point, I didn't know at the time. No one knew at the time, but the prosecution team had investigated the judge, trying to expel him from the case. And they didn't succeed in finding what they wanted to in the investigation. None of us knew that. And as a result of the judge cutting their case out from under them, they surprisingly dismissed the case.
Okay.
And I was unexpected. Although it seemed to be that's what they should do because my belief was that Barry was innocent and they didn't have the evidence to prove it, regardless of the experts or not. It was surprising they dismissed it. And they claimed that's because they found Barry's wife's remains somewhere and they just couldn't get to it before the trial because it was buried under snow and it would be so unfair for Barry. All of a sudden they cared about Barry Morphew's rights and his rights of a fair trial. So they dismissed the case on the spot with this document that they filed right before we entered the courtroom. And in the courtroom, they had summoned, I don't know, a large amount of media into the courtroom in this very far off, remote county in Colorado, in Southwest Colorado, in this small little courtroom and courthouse. And it was strange to me why these media people were there for this, what would be perfunctory, trial status hearing, right?
Mhm.
So when they dismissed the case, I was upset, I was hurt, I was angry, I was disillusioned, I was disgusted. And I asked my client if I could speak to the press because going public was not my instinct. Lawyers are trained to be careful, and I'm careful, but there are moments when silence protects the wrong thing.
Mhm.
And I didn't go public to shame people. I went public because the public deserved the truth. This was a widely covered case nationally, and with these true crime podcasters that the prosecution was teaming up with to help them convict Barry, being on podcast called Profiling Evil, and so I didn't go public to shame them. Attorney regulation. And so what I did is I had the press conference and I followed up with a very lengthy a complaint against the 7 prosecutors that were on the case to the Attorney Regulation Council, who regulates attorney licenses, right? So whether or not someone should have a license, whether it should be suspended, just like a doctor or nurse or any other, professional that's licensed. And attorney regulation itself recognizes that some misconduct must be public. So it's not just me being bold. That attorney regulation recognizes that. And that's why one of their sanctions that attorney regulation sometimes enforces is something called public censure. And that's not to humiliate lawyers, but that's to protect the public and inform the profession and deter future misconduct. So if the system, if I remain quiet and the system remains quiet, it cannot teach, it cannot deter, and it cannot repair trust. So that's why I went public, and attorney regulation just followed, my path in making the findings that they made.
So, I know you're saying you were bold, and I know you're saying that there's these attorney censure, but the truth of it is that throughout the entire country, I
Yeah.
can count on one hand, truly
Yeah.
one hand.
Yeah.
I counted. For
Yeah.
my last book, I counted. There
I know.
are almost no prosecutors that are ever really held to task for what they do. And in your case, I mean, really, it's extraordinary. And in your case, the attorney in the Morphew case, the main prosecutor, she was disbarred, which is extraordinary as a recourse. I mean, that's theoretically what's supposed to happen when a prosecutor violates their ethical obligations. They can be disbarred, particularly because sometimes it costs people their entire liberty for decades. And it happened in your case. So that's kind of extraordinary. And then 2 other prosecutors, to your point, received public censures. Again, very unusual. But that didn't quite feel like justice was fully served, right? Because Barry Morphew filed a civil lawsuit, and that was dismissed because courts said that prosecutors have absolute immunity. And that really brings us to PEP, which is PEP, which is Protect Ethical Prosecutors, the organization that you founded. And so I want to break this down carefully because
Yeah.
a lot of the listeners are not attorneys. What do you mean, or what does the court mean, or what is this absolute immunity thing that prosecutors have? Because police officers have limited liability, right? They can be held accountable in certain circumstances. It's still very high bar, very difficult to hold a police officer accountable for their misconduct. But prosecutors cannot ever be held civilly accountable for their wrongdoing in office. Can you
Right.
explain that?
How absurd it is, and um, how there's not a single person I've ever talked to that that responds to me like, well, of course. When you say to somebody, you can't sue a prosecutor when they intentionally or knowingly hide evidence of your innocence, There's nothing you can do about it. If you go away, your friend goes away, your family member goes away to prison for 30 years, decades. There's nothing that can happen to them. Like civilly, you can't sue them. And people are shocked that they are absolutely immune. So I want to talk about that, but I want to go back to something and when I explain that, okay? So the prosecutors in Morphew, go back to that for a minute. You're right. I don't want to discount how unique that was. And because it is very rare that a prosecutor is held accountable. And the point of what we're doing at PEP is that it should not be historic. Okay, that a prosecutor is held accountable when they commit misconduct. Yet it is, because Linda Stanley and the two prosecutors that were she was disbarred, and the two prosecutors, two of the seven, two others, they were publicly censured. All right. So by the way, public censure means their names goes out and you're supposed to know that they committed misconduct. No one knows their names. No one knows. So what effect is that really having on anybody? And by the way, the public censure and disbarment of Linda Stanley, it's also supposed to cause a ripple effect to other prosecutors to say, ooh, watch out, this could happen to you. And the fact of the matter is nothing's changed. Okay, we are watching and tracking misconduct in Colorado as if none of that ever happened, because I think that that's just a unicorn. That's just a really bad prosecutor. That's just one. And the point is this: the fact that the consequence is so rare is the problem, right? Because she is the only prosecutor in Colorado that's ever been disbarred for case-related misconduct. Okay. And what you said is true. It is of the exonerations, this is kind of a big statistic, but of the exonerations in the United States, we're nearing 4,000 people, even though we believe that 100,000 people are in prison right now that are innocent. Okay. But it takes a lot of energy and time and free lawyers to uncover and assess cases where there have been wrongful convictions. Okay. But of the 4,000, all right, of the approximately 4,000 people that are exonerated, meaning that they were wrongfully convicted, they're actually innocent, actual innocence, right? Of those people, more than 30% of them, prosecutors contributed to by committing misconduct, like hiding evidence of innocence being one of the highest categories. Of those prosecutors, the ones that committed that unethical conduct, less than 2% of them have received any type of professional discipline. That's how rare it is. Just what you said. They rarely have anything has happened to them. Disbarred, publicly censured, suspended, anything. And so when you get to immunity, this is what you get to. Okay. So we have prosecutors who aren't scared of attorney regulation because nothing happens to them, right? And that was supposed to be the cure, as far as the Supreme Court decided 50 years ago this year. 50 years ago this year, the United States Supreme Court said, you know what? I understand that this guy, Paul Imbler, was on death row because the prosecutor withheld evidence of his innocence. And he sued DA Pachtman in order to say, look, you should be held accountable for me losing my 14 years of my life. The United States Supreme Court said, you know what, there's other ways to deal with Mr. DA Pachtman, okay? He can lose his law license, which he didn't, and nothing ever happened to him, and he can be criminally prosecuted, right? Like every other criminal. Well, he was never criminally prosecuted. And so 50 years ago, that became the message that we don't want to tie up prosecutors with frivolous lawsuits and having them to have to decide between, am I going to get sued or should I go after this bad guy that I think is bad, but I don't really have the evidence really. Because we have these other mechanisms to hold prosecutors accountable. And the Supreme Court enacted their own law. There was no law that said there's no federal law that said that prosecutors are immune. Okay, never. And so they decided that on their own, and that has been followed for 50 years. And what we know to be the truth is that prosecutorial misconduct is evident in every state. It is rampant. It is an epidemic, and it is not stopping because there is a gap in accountability. Not a single prosecutor has ever been criminalized for their misconduct. Yeah, there's one sent to in criminal contempt, Michael Morton, who was wrongfully accused of his wife's murder, right, by Ken Anderson. Do you have Nifong, who I think might have spent a day in jail for the Duke lacrosse players being wrongly accused, where he withheld the actual DNA of the true offender. Okay, so we have rarely seen, and Ted Stevens, Senator Ted Stevens, the most phenomenal wrongful prosecution in U.S. history. Nothing happened to those Department of Justice prosecutors after a 400-page report came out highlighting and shining a light on how they lied and crafted documents that weren't true and hid witnesses that showed that he was innocent. So the Imbler case 50 years ago needs to catch up with the modern era. We have DNA that proves people are innocent. We know the prosecutors want to win at all costs. They get elevated. They become senators. They become legislators. They have a lot of power over the legislator in the legislators in order to, keep them happy. And so we need, and this is the deal. I'm not here, and PEP isn't here to get in the way of ethical prosecutors. We're here pro safety, pro ethical prosecution. Weed out these unethical prosecutors, weed out the misconduct, and we are going to have a trustworthy system where we know that the first chance that people get to experience in the criminal is going to be fair. There's going to be less wrongful prosecutions. There's going to be less people that shouldn't even be charged in the system where there's no crime. So we know that that is a preventative measure. So why not implement it in a fair way?
So I think I want to unpack that for a minute and then get to sort of the nub of what's happening. So when a prosecutor engages in misconduct, they can be theoretically criminally prosecuted, but that would require a prosecutor willing to prosecute a prosecutor, which doesn't happen and hasn't happened. They can be disbarred, they can be publicly censured, they can be privately censured, which means like they get a letter that says, oops, you did that bad thing, don't do it again.
Exactly.
And they can be suspended, they can be required to do classes, whatever.
Exactly.
It almost never happens. Any of those things almost never happened. And again, the disbarment being the most serious sort of consequence because it removes their law license. But we have this doctrine of absolute immunity that says you can't sue them. Whatever you do, you can't sue them. And you're saying, what is PEP's vision? Because the Supreme Court is very clear. It's affirmed it not that long ago. In Thompson's case, John Thompson was a guy in Louisiana who got the prosecutor was egregious in what he did and won $14 million that the Supreme Court said, nope, you can't sue the office. So I'm just wondering, what's your vision? How are you going to get to accountability when the Supreme Court says, no, not civilly? What are you thinking? What's your vision?
Well, it's no different than any other Supreme Court created law, right? So kind of similar to abortion, like the death penalty, right? They start creating their own common law. That's what it's called. And how do you mechanize that? Well, you can pass law in your state. State law can be passed in order to say what the state should do. So if we enact laws state by state that say prosecutors should not be immune when they commit intentional or knowing or reckless misconduct harming somebody, then that will not be a bar to them being able to sue. So as long as we're not suing in federal court, which is not what we're trying to change, we're just trying to change state law. So we want to implement state law that says, look, if a prosecutor lies, and they knowingly do it. It's not good faith mistakes. Okay. We're not talking whoopsies. And we're not talking, by the way, we're not talking guilty people. We're talking people whose cases have been dismissed, their convictions had been reversed, or they've been acquitted at trial, where the prosecutor has lied, has hid evidence of innocence, or has destroyed evidence, have put on false evidence into a trial or a hearing, right, that has caused this damage to the person. And then that person will have the ability to sue the prosecutor in state court, and they will not have this immunity, the federal immunity that the Supreme Court decided they should have.
Let me push back on what you just said a little bit, because you said it only applies to the innocent, the factually innocent. I'm wondering about that. Why? Because one of the things that I love about wrongful conviction litigation is that the benefit that comes from correcting the things that cause wrongful convictions benefits everybody in the system. And prosecutors play fast and loose. I keep using that expression, but it's the one that keeps coming to mind. They hide evidence and do things that are unlawful or unethical in cases involving factually guilty and factually innocent people, because at the time of their misconduct, the defendant is presumed innocent. And so I'm wondering why you're focusing so exclusively or so targetedly on the innocent.
Okay, so I'm not focused on the innocent. I'm focused on people who have had their charges dismissed, they've been acquitted, or their conviction was reversed. And the reason why is because I want this legislation and or ballot measure to pass. Okay, so listen, the first brick of this structure, this really broken structure, needs to fall. Okay, and if it doesn't make sense if we go in and we say, we're talking about a broad measure. We just want to get rid of all immunity for prosecutors, no matter the circumstance. I don't think we're going to get very far. I think the truth about policy and making change and reform, we have to take a bite-sized piece out of immunity that makes sense, because what we've done is we've tested this message. All right. And we've done a poll, and with a very, very well-known and trusted polling company, and in Colorado, and 83% of Coloradans, regardless of demographic, okay, party, political party, age, where they sit, liberal, progressive, their age, their gender, 83% support eliminating absolute immunity when prosecutors commit intentional, knowing, and reckless misconduct. All right. And so understanding that, I think if the prosecutors were able to say, okay, right, so every person who's upset with us is going to be able to sue us. So that people get convicted, and they're mad at the prosecutor, because they're mad at the prosecutor, maybe because the prosecutor lied, right? But at this moment in time, what they're asking, if we went in with this broad policy, right, I think we lose 83% of the people. I feel like we need to support some measure of real careful, narrow measure. That's what we need to support, because prosecutors then will be able to say, oh, great, we're going to end up in court every day for the 10 people that we prosecuted today, right? But the point is this: if we keep this in a very structured, rational, tied to science, tied to scholastic and academic research, I think we can make a big difference and divot. Because this is the point. This is not about suing prosecutors for losing or for making hard calls or good faith mistakes, right? We know the public safety isn't served by that. We want to deter prosecutors from doing this. We want to deter prosecutors. We don't want prosecutors afraid to do their jobs. And that's what's going to happen. If they can be sued at any time by anybody who's just not happy with them, right? don't want them to be afraid to charge dangerous people. We want them to do their job, right? I think if we do commit to a policy that is very narrow, then we're going to be telling them, look, put your self-interest aside and put your 529 account for your child's college education out of your mind right now and do your job and just don't lie and don't cheat and follow the rules and you won't be sued. But I think if we open up this large, broad area of, civil liability, I think we're going to end up, I think, losing the message and losing the deterrence.
And so, yeah, I totally get what you're saying. I just was curious about that.
I get
Um,
it. I get it.
yeah.
I just don't want to chill ethical prosecution. I want to chill misconduct.
Now, how's it going? So, what's been happening? You've been pushing for these laws or this changes in legislation. Where have you started, and what's been happening?
Well, I think, there's momentum, but momentum isn't the same thing as change. All right.
Mhm.
I think the boulder's moving, but it's not moving fast enough. And we need to teach people about this. No one knows that prosecutors are immune. A lot of people don't even understand this is a problem. They don't understand that when prosecutors are out there in the world right now, in their elections right now, you have, our president talking about it, you have senators talking about it, no one should be above the law, right? No one's asking prosecutors, well, what about you? You're
Mm.
above the law. What about you? So first is we're working on the education. And what we're seeing is that people are starting now to understand that, oh, wait, they're not disclosing evidence. They're pressuring witnesses. Their forensic claims are overstated. And we're starting to teach people that, yes, this actually does happen where prosecutors mislead courts. And and wrongful convictions aren't accidents of fate. We're starting to teach people that they're a result of choices that prosecutors are making.
Mhm.
So I think once we get to that point, and also teaching people that I believe prosecutors are ethical. I do. I do. And it's a good prosecutor, someone who doesn't want to win at all costs. Right. And so when we're able to send that message that a prosecutor's client is justice, right? It's not a victim, it's not the law enforcement agency, it's justice. And that's a prosecutor discloses evidence early and all of the evidence. They correct their mistakes. They might even apologize. Their job, that's their job. And when we get people to really wrap their arms around where we're coming from and where we're headed, I think we're going to do a better job. Because right now, we are campaigning for either a legislative change or a ballot proposal in Colorado to set this off. And what we need is a lot of public agreement and sentiment and understanding about these issues in order to get there, because we're
Mhm.
we're not there yet. In Colorado, qualified immunity has been eliminated for law enforcement, which means a law enforcement in many other states can say, well, I didn't really understand that beating somebody over the head 10 times was against the Constitution. I just thought it was 9 times, right? And then they can't get sued. That's qualified immunity. Well, that was stripped away in 2020. And so we believe that it's a natural next step to say, well, why are prosecutors so special? They're contributing in these wrongful convictions, these wrongful prosecutions, this wrongful charging. Coloradans already have agreed with that. So why not add prosecutors to that in a very measured way? So that's our next step. And prosecutors are having a hard time with it, Jessica.
Mm.
They are resistant. They are scared. They are creating fear with the public. They are telling the public, oh, we're not going to be able to go after dangerous people. It's going to cost you lots of money. The sky's going to fall. Oh boy, oh boy. They're telling legislators, things like, well, looks like you're soft on crime. I wonder if you're going to win your next election.
Mm.
They're very powerful. They're powerful in the legislature. And there's very few who will come out. In fact, one elected DA has come out in Colorado and bravely said, "I agree. Misconduct happens, and we need to hold them accountable. And I'm okay with eliminating immunity in certain circumstances." One prosecutor elected bravely said that. All the other ones, no way. No way are you going to pierce this amazing vest that we have, and we're protected for intentionally lying and hiding evidence from people. We want to continue to have that life. We like that life.
Oh, yeah, sure they do. Now, so that's Colorado. That sounds like it's your staging ground. And you've been appointed to the National Association of Criminal Defense Attorneys Task Force on Prosecutor Accountability, and you've presented at the Quattrone Center over at University of Pennsylvania, which is one of the leading resources on conviction integrity units. And I'm just wondering, do you find is there momentum for this nationally? So, you have some inroads in Colorado. You've got this
Yes.
precedent of this disbarment of the one attorney on your case. What's the landscape like nationally?
It's growing, and I want to say that look, and as I kind of said, the immunity doctrine is deeply entrenched.
Hmm.
Prosecutor associations are very powerful, but this is interesting: is that the more they speak out against wanting to be immune, which they're doing now more and more as we're getting a bigger stage, the more the public is understanding and worried that they're being so protective and there's a lack of transparency.
Mm.
And so nationally, it is our movement is growing. I was just at the Innocence Network's Innocence Project's conference over a weekend in mid April, a couple weeks ago,
Mhm.
and in Chicago, and it is a panacea now that we're doing this. That people, exonerees, can't even believe this is possible, and we're like, no, it's possible. What? Why is this impossible? This is this is not based in Iris's revenge. This is actually based in preserving justice and the
Mm.
truth, and
Mhm.
they're seeing that. And people all over the country have been contacting us saying, "Can you do this here? Can you do this in New York? Can you do this in Georgia? Can you do this in New Mexico?" And we're saying, "Yeah, we can." We need to get the message out to the public so they understand what it is we are doing, and we're coming to you next.
Right. I love that. I'll see you in New Jersey.
Great, great. New Jersey needs it. Everywhere needs it.
Everywhere needs it. Everywhere needs it. It's an issue certainly very near and dear to my heart. But let's just, this has been a great conversation, Iris. And I want to just bring it back to sort of what we do here on the podcast most often. We just talk about second chances. Just Justice is about second chances in the criminal legal system. And so I'm just wondering, as we sort of bring this conversation to a close, for people who've been wrongly prosecuted or convicted, what do you think a second chance should look like after damage has been done?
I mean, a second chance, can rebuild a life. And, a second chance after wrongful prosecution, it's complicated. You know that because the damage isn't theoretical. And people I've seen, you've seen people lose their jobs, their homes, their savings, their reputation, their marriages, their years with their children. Some lose decades, and some people recover and some never do.